My name is Shannon Reed. I am the Director of Communities for the Electrochemical Society. ECS is hosting this webinar on visa and consular issues for short-term travel to the United States to assist those individuals who are interested in attending any of our biannual or sponsored meetings. This year, we have our 235th meeting in Dallas, Texas, starting on May 26th through May 30th. We have an ECEE meeting that's occurring in July of 2019. And then we have our 236th meeting in Atlanta, Georgia, and abstracts are still open for that meeting until April 12th. So we hope that this workshop in particular on the visa issues and consular concerns will be of assistance to those individuals interested in attending. So Brendan, I'll go ahead and turn it over to you for your introduction.
Okay, so thank you, and again, thank you for inviting me to do this webinar today. I hope that the information that I am able to provide to your members is going to be helpful, informative, and it will assist many people with the visa application and indeed for obtaining a visa to one of the upcoming meetings that you guys are hosting, perhaps Dallas in a couple of months, or potentially maybe more so Atlanta in October. Excuse me, I do have a little bit of a cough, so if that kicks in, just bear with me during the presentation. A little bit about us. We are an immigration law firm located in Washington, D.C. area, and we work extensively with scientists and researchers on their U.S. immigration and visa issues. So as we sort of navigate through this today, I do want to just sort of clarify that what the information I'm going to provide to you guys today is not legal advice per se. I want you to take it as being informational, educational in nature. But if you have a particular specific question for your own personal situation, you should talk to an attorney. We are available ourselves, but you should talk to an attorney with regards to your own personal situation and case. So with that in mind, we're going to go ahead and now sort of navigate our way through this process. So what do you want to do? Well, this shouldn't be news to anyone. You need to be prepared. And so how does one get to be prepared for obtaining a visa to come to the United States? Well, there are a number of issues, and we're going to sort of walk you through them over the next sort of probably 20 minutes or so, 20 to 30 minutes. How you navigate it, the order in which you do these things. There is not one required order to do, to process the paperwork, but generally speaking, you'll want to get everything properly prepared in order to navigate the process. So first of all, you do want to understand why you're coming to the United States. You will be coming to a scientific event, a scientific conference or symposium. And so therefore, one of the things that you will want to provide to the consulate is the why. Why indeed are you coming to the United States? And the Electrochemical Society will no doubt be able to provide you with a letter of invitation or a letter describing and discussing the parameters of their conference. This can show the US consulate or embassy that you will indeed be coming to the United States for a legitimate and bona fide reason. Now, I don't know if any of you have come up against this issue in the past, but check your passport. If you're ever traveling internationally, the worst thing that can happen is just as you're getting ready to leave, you realize your passport is expiring. So keep that in mind ahead of time. It's got to be a valid passport. You're going to want to have at least 6 months validity after your departure from the United States. That's after you return to your home country. So check your passport early because if the dates don't align, you'll want to go and actually get that renewed before you in fact initiate the visa process. And as we sort of walk through this over the next few minutes, the next 20 minutes or so, familiarize yourself with the necessary information for the application, and ultimately I think know which visa process applies to you as you approach this. There's going to be two main visa processes that we're going to talk about. So the first one is the easy one. That's the visa waiver process. Basically, citizens from a number of countries around the world are eligible to come to the United States using what is called a visa waiver. In effect, they do not need to present themselves at a US embassy to obtain a visa stamp in their passport. The list of countries can be looked at in this link from the US State Department. And if you are eligible for this process, this is the way to go. It's what I would term the path of least resistance. Important to note that travel itself must be for a purpose that would otherwise be allowable on a B visa, the B visa being a visitor, tourism, or business-related visa. And you must register in what's called the ESTA system. But again, neither of these issues would be problematic for coming to the United States to attend a scientific conference if you are in fact eligible for this visa. I'm from Belfast, Northern Ireland, so if I was coming for a scientific conference, I would in fact be eligible to use this visa, and this would be the easiest way to come to the US for a conference such as this. But a couple of things to keep in mind. Are you in fact eligible, i.e. are you from a country that would enable you to come to the US on the visa waiver, but is there something else that would preclude you from being in fact able to use it? And here are reasons why you may not be eligible for the visa waiver country, the visa waiver program, excuse me. If you are from a country that would otherwise be eligible for it, but you have in fact traveled to or been present in a list of countries as noted there, then you are ineligible for the visa waiver program. So the United States have indicated that for certain security reasons, if you have in fact traveled to or been present in some of these countries, you will have to present yourself and obtain a B1 visa. Similarly, if you are a dual national of certain countries, you are also ineligible to use the visa waiver program and would also in that circumstance have to get a B1 visa. Furthermore, if you have previously violated the terms of the visa waiver program, you must in fact go and apply for your own B1 visa. One example of this could be, for say you had come to the United States on the visa waiver program previously. It enabled you to stay up to 90 days in the United States, but you had in fact stayed for 92 days. Therefore, that would be considered to be a violation of the visa waiver program, and subsequent entry to the United States must therefore be on a B1 or B2 visa. Well, the next question is, how do you apply? And it's fairly easy. You go to the CBP website and you complete an application. It's the ESTA program. You can check your status on the same website. It's a fairly seamless process. And once you're approved, you can then come and travel to the United States on the visa waiver program to attend the scientific meeting or conference. Excuse me. But what about if you're from a country or otherwise ineligible to use the visa waiver process? Then you got to think about a B1. That's not a B1.5, that's a B1/B2 non-immigrant visa. One thing that I would like to note at the outset here is that even though these terms are used interchangeably, and what I mean by that is many people, including indeed consulate officers, will at times use the term B1, B2 interchangeably, there are discernible differences. The B2 visa is for tourism and leisure. The B1 visa is for business and related processes such as that. So even though indeed in many instances the term B1, B2 is used interchangeably, it's important to note that for purposes of an application for a B visa for a scientific meeting, you should in fact be applying for and utilizing the B1 visa. And so that's an important thing to note at the outset. So once you determine that, the B1 is in fact the appropriate visa for you to utilize, what do? Well, first of all, while I am talking generally today, I think it's important for you to personally review the consulate website from the location in which you will be applying, as many consulates may have local rules or could have slightly different policies or procedures than other consulates. So there are going to be some local and location differences. Generally speaking, the process entails completion of the DS-160 form online. That's a Department of State form, which you then submit with digital pictures. Once that is done, then again, through an online system, you would make appointment for the visa interview and pay the non-immigrant visa fee. Generally speaking, they want to see your biometrics, fingerprints, things like that. So you would then go and you would make an appointment, excuse me, for biometrics. And once the biometrics are taken, then you should be able to be scheduled for the interview itself. And as I said earlier in this slide, and again, I would just like to reiterate, the B1 visa is the appropriate visa to request. And again, you're going to potentially see, read, or hear about the B1/B2. And again, even though they can be talked about interchangeably, be careful in your application. Make sure and request a B1. Now, before we even get to the interview, I want to bring up which may be the singularly most important aspect of what to be prepared for, and that is 214B. 214B is when the consulate officer makes a determination that you may have what's called immigrant intent. Do you have enough? A 214B denial is in effect where the US consulate officer feels that the applicant was not ready, willing, and able to provide enough documentation to convince the officer that they would in fact be returning to their home country. So just as earlier in the process and in this presentation, we indicated that you should have documentation showing that your trip to the United States is indeed for a legitimate and bona fide reason, i.e. the scientific conference. It is equally, if not more important, to have documentation in your possession that can show the consulate officer that after the end of the conference, that you will in fact be returning to your home country. How do you do that? Generally speaking, letter of employment, salary, wages, housing and living details, and family connections to your home country. So these are the issues that, in addition to when you initiate the visa interview, you provide information about your reasons for coming to the United States. It is very important that in the visa interview itself, you are in fact prepared to show the consulate officer that you have substantial ties to your home country and that you are able to provide substantive documentation and evidence to convince them that you will in fact be returning to your home country after the conference. So you turn up, you get the interview scheduled, and you're ready to go. What do? Well, be prepared and organized. Just as I spoke about some of those issues in the previous slide, make sure you have your documentation in a well-organized folder and be ready to talk about things specifically, but also succinctly. I think it's important to note that these interviews will generally be quick. Consulate officers are generally overworked and don't have a lot of time. So you need to be able to be prepared and be ready to quickly talk about the reasons for your attendance in the United States, and also be ready to answer any questions about your return home after the conference itself. Answer each question truthfully and fully. The consulate officer will ask a question, answer it. However, it's not necessarily to volunteer information outside the question. You know, we just want you to answer the questions succinctly, truthfully, and on point. And there may be a slight language barrier, so therefore if you don't understand the question, it's completely reasonable to ask them to repeat or rephrase the question, or potentially just ask you something a little slower, just so you can gather your thoughts and indeed ask or answer the question as needed. Be prepared again with the documentation to bring up any claim that you are making. If you are going to the conference at a certain location, bring your hotel reservations, if you have made them, registration information, letter of invitation. Again, this goes back to your reasoning for visiting the United States. But more importantly, be ready to show those home ties. Your job security, lease or ownership of property, family ties, things like that. Those are the two main issues that will come up, and indeed it is your departure from the United States and your return to your home country that will generally be most heavily scrutinized by the officer. Sometimes being nice goes a long way, so just try and be courteous even if the officer is not. Keep your cool, be calm. At the end of the day, they're just doing their job. Excuse me. Now, once the interview has taken place, you may have read, heard, or been informed about something called administrative processing. What is it? Consular officer may simply just be happy with you and give you the visa. But if not, administrative processing, which is under section 221G, in effect allows a consulate to delay giving you an answer because additional time is needed to ensure that you as the applicant are both qualified for the visa and admissible to the United States. And this is certainly one of the reasons why applications for US visas should be made well ahead of time, because the closer you leave it to the sort of date of the conference, if you run into what we call 221G processing, it can ultimately delay your application and potentially lead to you not being able to attend because they have not made a final decision. Technically, administrative processing is, as stated there, just a delay in adjudication. However, at certain consulates and in certain situations, it's almost practically speaking treated as a denial and can lead to the need to actually reapply for the visa because nothing happens. Why would you be involved? Why would you get a 221G letter? There's generally speaking sort of two reasons why one would get a 221G administrative processing letter. It's either additional clearance from the US side of things, or the consulate needs some time to conduct some additional research on their own behalf. Generally speaking, if it's a US clearance issue, it could be because of criminal activity, security issues. Your name may be similar or the same as someone else who has been engaged in criminal activity with terrorist ties, and these could all trigger additional processing of your individual application. If the delay is on the side of the US consulate, this would usually be because they may be, researching the legitimacy of, for example, a marriage that you stated you had, potentially your work history, authenticity of documents, or something to that effect. If you are issued a 221G letter, it's important to keep on the consulate, to keep engaged with the consulate so you can make sure that they are in fact processing your application and that it didn't sort of go from a desk to a pile of papers. Because if you get sort of lost in the shuffle, you may need to potentially reapply. So generally speaking, there will be phone numbers, there will be email addresses, or if you are at a location that it is convenient to attend, you may be able to make an in-person appointment just to make sure they are in fact processing your application. And there it is. Just as I said, 221G is the big reason to get started early in this process. Where should you apply? Well, again, generally speaking, it should be your home country. US embassies and consulates will generally look most favorably on people applying for your home country. However, if you're residing in a country that's other than your home country, the country where you're in fact residing in should allow you to apply there. Certain consulates, mostly Canada and Mexico, will process and facilitate cases for what we call third country nationals. One point to make in the where should I apply section, US State Department discourages what I would term forum shopping. And that means, for example, if you were previously denied a US visa at a US embassy or consulate at a certain location, they tend to look unfavorably if you try and reapply somewhere else just to try and get a different decision. So that's something to keep in mind. And again, generally speaking, you would apply in your home country. How long will this take? That can be a difficult question to answer because there is a lot of inconsistencies and there's a lot of differences with consulates around the world. There is a US consulate, a link to different US consulates. You can plug in the consulate or embassy that you would be attending, and that will give you the different time frames. One example that we pulled from this list previously was Abu Dhabi, where the wait time for a visitor visa was 8 calendar days. Important to note, this is the time for you to get an appointment and does not include the post-interview processing. So don't look at this and say, okay, well, the time frame is 8 days. The meeting in Dallas is, at the end of May. I can leave this to the last minute because it's going to take 8 days. That's incorrect. That's generally the wait time to get the appointment. Okay, so the subsequent processing of the visa, hopefully it'll come back quickly, but that can take, depending on how long of your specific application. So again, start early, get the visa issued in time. One thing to understand, that when you show up and turn up for a visa interview and an appointment, this is not just about what's happening in the immediacy. If you have previously applied for a US visa, if you have previously come to the United States in some manner, using some status, it's all in play. Your entire US immigration and visa history is in play during your visa interview. So understand that it's not just what is happening in that specific moment, but they can look back through your history. What about misrepresentations and crimes? Well, let's start at the top. Under that section, we have what's called misrepresentations. Generally speaking, a misrepresentation to effect this must be what we would call material to obtaining an immigration benefit. However, it is, I think, fairly clear, I say here many have reported, I think it's fairly clear that in many instances, any type of misrepresentation can be used by a consulate officer as an excuse to deny an application. And therefore, this goes back to what I mentioned earlier, what I noted earlier, is to be prepared and to be organized. Be ready with your answers, be prepared, because therefore you will be, generally speaking, more comfortable in answering questions. And again, as I said earlier, if you are being asked a question or you feel you need a little bit more time, just ask them to repeat or rephrase the question. But again, generally speaking, just as in life, the better prepared you are, the better you will be able to answer and respond to your questions. If you get hit with a misrepresentation issue, you can ask the United States Department of State to intervene. But again, that could take weeks or even months. However, every time I sort of talk about some of these issues, you can see the earlier you sort of apply, the better. This can be made more difficult in that the consulate may or may not even tell you what the misrepresentation was. Certain consulates are notoriously obtuse. They may just indicate that there was a misrepresentation. They may not even indicate what it was. What about criminal issues? One of the problems here, one of the issues here, and again, I'm generalizing here. So, for example, if criminal issues apply, this is not necessarily the forum for me to engage and answer specific questions. But it's fair to say that Department of State, USCIS, CBP, they don't necessarily all agree on which crimes or issues render someone inadmissible. A couple of things to keep in mind. Cautions, or something similar to that, which are quite commonly utilized in the United Kingdom, for example, may not necessarily be considered to be convictions or admissions of guilt in your country, but for purposes of US immigration and the State Department, they can be considered admissions of guilt by the consulate, because generally speaking, they required an individual to admit to the elements of the crime. Continuation of crimes and social media. Hopefully the crime thing doesn't apply, but you know, it's an important issue. So what could the other possible issues with travel be? DUIs and DWIs, driving under the influence or driving while intoxicated. If you have had an alcohol-related offense, the State Department, even if you have a US visa, may indeed revoke your visa. So if, for example, you already have a B1 from a previous visit to the United States, but then you had an alcohol-related conviction, you may need to, in fact, go and reapply to get a new visa stamp. Generally speaking, at a minimum, the consulate or embassy will require you to present yourself to a doctor to show that you're not alcohol dependent or something similar. And this process, unfortunately, can be somewhat inconsistent, again, at the various different consulates and embassies across the world. Some of these other issues that are a little bit more difficult to quantify in the current climate is the idea of what's on your social media, on your phone, and your computer. They can look at it, and they are looking at it. There is a proposal to request potentially usernames and details for all social media accounts using over the last 5 years. That's a State Department initiative. Let's see where that goes. I think it's a good idea to be careful about having certain confidential information on devices when crossing into the border. And again, some of this is hard to quantify, but if you are posting on social media that something that may be inferred to be an anti-US post, political posts, things like that, it is entirely possible that a US consulate officer or indeed border officer upon admission into the United States may review that upon entry to the United States. Many people are aware of the travel ban. What I will say is it is in effect. I'm just going to put this up here. There are different issues that affect individuals from different countries. You see it there. There's quite a number of countries that are affected, and this is going to be, if you're from one of these countries, it's going to be difficult because while there are potential waivers to the restrictions that are incorporated in the travel ban, it is clear that they are very rare and that they are very difficult to get. In effect, if you are from one of the countries listed in the travel ban and affected by the travel ban, I think it's clear that you should take legal advice and see where you sit in terms of potentially even being able to navigate this process. Which is the more sort of nuts and bolts of the issues affecting the travel ban. Dual nationals can still travel and indeed get visas based upon another nationality besides the nationalities listed in the previous slide. So as an example there, if you were a national of both Iran and Canada, admission to the United States on both a non-immigrant or immigrant visa would be allowable based upon one's Canadian nationality. Second of all, people who were in the United States at the time the travel ban took effect were not affected. Generally speaking, if you already have a valid visa at the time the travel ban was put into effect, you would be exempt from those restrictions and could continue to use the previously issued visa. Permanent residents of the United States, If, for example, you are on sabbatical or on a hiatus internationally, you can always return to the United States using your permanent resident card, and you would be exempt from the travel ban. There are potentially other exemptions as well, but again, I don't think we don't really have the ability to get into the weeds of it here, I suppose, in this forum. Again, what I would suggest is that if you are from one of the countries listed, you should talk to an attorney to see if there are any avenues or paths that you may be able to navigate. Okay, so you've navigated the visa process, and the US consulate have given you the visa to come and attend the scientific conference, and so you come to the US. So you're here, what to do and what not to do. Please adhere to the requirements of your visa. Don't come as a B1, non-immigrant and engage in unauthorized employment. It's not allowed. Now, there is a new 90-day rule. What this does is, this can, and this is a little bit subjective, but again, under where I note the new rule, generally speaking, if you were to take actions that could be construed as violation of status within 90 days of entering the United States, then you could be seen to have a presumption of misrepresentation or fraud, which could have implications for the future. What does this entail? For example, if you came to the United States and they said, okay, you can stay for 90 days, and within 30 days you got married to a United States citizen, that could entail what, in the future, that there was a presumption that you misrepresented upon entry. So basically, when you come to the US for the scientific conference, for the scientific meeting, come engage in the meeting, be involved in the meeting, present if you were selected for an abstract, but don't engage in actions that would be considered to be unauthorized for purposes of your visa. So with that in mind, we've hopefully got you here. We've got you attending the scientific meeting, and then at the end, you leave and you go home to re-engage in your employment or other activities back in your home country. So with that in mind, I'm going to say thank you. Thanks again to Shannon and the Electrochemical Society for inviting me to give you this information today. And I hope that what I was able to provide to you was helpful, informative, and that you will have a successful visa application in the future. So thanks again.
Thank you, Brendan. We really appreciate you providing this to our constituency. We do have a couple minutes, so I did want to offer an opportunity for anyone to ask any general questions. Feel free to enter them in the chat box. We'll wait a couple of seconds to see if there's anything there, and then Brendan can reply. If not, we'll go ahead and close out the webinar, and we will make it available online.
Oops.
All right, so the first question is, how can they obtain a letter of invitation? So that's typically done when your abstract is accepted, and ECS sends out that letter of invitation upon abstract acceptance.
Could I just make one comment?
Yes, of course.
Would you guys also provide letters to people who may just be in attendance at the meeting as opposed to presenters?
We can provide a letter of attendance after the meeting once their attendance has been confirmed and they picked up their badge registration.
Right. Okay.
Mm-hmm. Are there any other questions? Oh, so Brendan, Ben would like to know, what should they do if they've been denied once before?
Yeah, that's a good question. And one of the things is there is a doctrine of what's called consular non-reviewability. And I think that if you were denied before, it's important and almost imperative to get professional advice as to how best to navigate the reapplication. because depending upon what transpired the first time around, you may need to sort of re-engage with how you make the application and or how you present things. So it may indeed depend upon why the denial was issued, what the reasons were, because then, you know, we could make a fair determination on what your chances were next time around. If it was, you know, if you unfortunately had made some practical or procedural mistake in the application, then it may be as simply as sort of re-engaging with the consulate and saying, look, I did this incorrectly and here's my new application. But if there are other more substantive issues, then I think it would be certainly, it may be more difficult. But again, that's a personal question, and I think we would want to review the circumstances of the previous denial before making an informed decision on how best to proceed.
And Brendan, are there any other questions that you typically run across that might be of use, at least for an answer to, for the attendees today?
I mean, the two questions that we got just now, I mean, again, being able to obtain, you know, a letter of invitation or other information from the society itself to confirm or show that the reasons for coming to the United States is legitimate, that's usually there. And really, you know, making sure if you were previously denied, I think to not just reapply, but rather seek advice and have someone evaluate the reasons for the denial to at least provide you with an analysis of what transpired the first time around. You know, other questions, you know, tend to be more potentially personal in nature. It may be specific to a person's, you know, situation, and this may not indeed be the applicable forum to engage with that. But I think those two questions that come up are certainly, you know, two of the more general questions I would see.
Great. Well, again, we would like to thank Brendan for his time today, and thank you everyone for attending. We are going to go ahead and review the presentation and make it available online on our YouTube channel and in the ECS blog. Again, feel free to reach out to ECS. We do have a visa webpage, and we can also provide follow-up information if you'd like to get in contact with Brendan at Franklin Delaney Immigration Law LLC. Thank you again. My name is Shannon Reed, and I'm the Director of Community Engagement with ECS, and I look forward to seeing you all at a future meeting.